Let me start with this. If you're listening right now with your heart in your throat because your mom or dad is in the hospital and they didn't sign a power of attorney, you are not alone. Maybe you're sitting in the waiting room or pacing in your kitchen or scrolling Google at 2 a.m. trying to make sense of what just happened. And you're asking the question that every adult child eventually fears: what do I do now? So let's talk about it. Let's talk about the panic, the paperwork, the power of attorney you don't have, and what legal tools still are available to help protect your parent and yourself right now. Welcome to Gavels Down, Voices Up, where we flip the script on conventional legal discussions. I'm Rachel King, here to guide you through the murky waters of estate conflicts, inheritance disputes, and all of the dramas. We're not just talking about law, we're talking about how it affects your life, your rights, your future, and your money. From the courtroom to your living room, we bring you insights that matter. Dive into each episode ready to challenge, learn, and grow. Ready to change the dialogue. Let's begin. Gavels down, voices up. Welcome to Gavels Down, Voices Up, where we tackle the real life, messy, emotional side of family law, estate planning, probate, and protecting the people we love. I'm Rachel King, board certified probate attorney, courtroom strategist, and a daughter too. I've walked people through hospital hallways, conservatorship hearings, and middle of the night, what do I do phone calls. And today I want to walk through this moment with you because if your parent is in the hospital and they didn't give anyone legal authority to act for them, you're facing a legal and emotional situation that's hard, complicated, and scary. Let's start at the beginning. What is a power of attorney? A power of attorney, sometimes abbreviated as POA, is a legal document that allows someone to make decisions for another person if they become unable to act on their own. There are two main types, one for finances and one for healthcare. The financial power of attorney lets someone pay bills, manage bank accounts, access retirement plans, handle taxes, all the boring but necessary stuff that keeps life running behind the scenes. The healthcare directive or medical power of attorney lets someone make decisions about treatments, surgeries, medications, and end of life care if your parent can't speak for themselves. These documents are incredibly powerful. But here's the catch. They have to be signed while your parent is mentally competent. And that means they have to be able to understand what they're signing, why they're signing it, and what the consequences are. Once they're unconscious, heavily sedated, mentally impaired by illness or trauma, it may be too late. And that's when people start to panic. They come to me and say, Rachel, my dad just had a stroke. He didn't sign a power of attorney. I can't access his accounts. I can't pay his bills. What do I do? Rachel, my mom's in ICU. She can't speak. Can I just sign for her? Is it too late to get a power of attorney now? Here's the honest answer. If your parent is not competent, as if they're no longer capable of understanding and voluntarily signing legal documents, then yes, it is too late to get a valid power of attorney. I know, that hurts. It feels like the door just slammed shut. But here's what I want you to hear loud and clear. That doesn't mean you're out of options. So let's talk about what you can do. Let's talk about the next step, a conservatorship. Now, if you've listened to my podcast before, you've probably heard me talk about conservatorships. They're not fun, they're not fast, and they're not cheap. But when there's no power of attorney and decisions still need to be made, a conservatorship is often the legal path forward. A conservatorship is a court-ordered process where someone, usually a spouse, adult child, or close relative, is appointed to make decisions for a person who can no longer make them for themselves. There are two kinds: a conservatorship of the person, which gives you authority over healthcare and personal decisions, and a conservatorship of the estate, which gives you authority over financial matters. Sometimes you need both, sometimes one is enough. Let me give you an example. A woman I'll call Gloria came to me recently. Her mother had been rushed to the hospital with severe dehydration, confusion, and what they later diagnosed as a stroke. Gloria had always assumed her mom had done all the paperwork, but when the nurse asked for the advance directive, nothing. No power of attorney, no legal documents, nothing. Suddenly, Gloria couldn't access her mother's bank account to pay the utility bills. She couldn't talk to the insurance company. She couldn't even authorize the rehab facility her mom desperately needed to transfer to. We filed for emergency conservatorship. We got temporary authority in less than 2 weeks, and we started taking care of everything: the mortgage, the medications, the Medicare appeals. It wasn't easy, but it was possible. So if you're listening right now and your parent is in a hospital bed and you're being told you're not authorized to act, this is your path forward. Now let's break down what the conservatorship process actually looks like. First, we get a capacity declaration from a doctor. This is crucial. It's a written form signed by a licensed physician or psychologist stating that the person is unable to make decisions due to medical impairment. Without this declaration, the court won't act. They need proof that your parent can't legally advocate for themselves. Next, we prepare and file a petition for conservatorship with the probate court. This document outlines who you are, what authority you're requesting, why it's needed, and who else might be involved or affected. Once filed, you'll get a court date, usually within 30 to 60 days for general petitions, sooner if it's marked as an emergency. In some cases, we also request temporary conservatorship, an expedited version that allows you to act immediately on urgent decisions while the full petition moves through the system. There's a hearing, there's notice to relatives, and there's sometimes an investigation or court-appointed counsel. The process can feel like a lot, but you don't have to go through it alone. And here's a very important thing I want you to hear. If you're doing this for your parent, you are doing an incredible thing. There is no legal obligation for adult children to file for conservatorship. You don't have to, you choose to. And that's an act of courage and compassion. Now let's talk about money, because I know you're wondering. Yes, conservatorships can be expensive. There are court filing fees, attorney fees, investigation costs, all of it adds up. But in many cases, once you're appointed as conservator, you can use your parents' estate to reimburse the costs. And there are fee waivers available if the estate is small or there are no assets. Don't let the money scare you into silence. You might be wondering, Rachel, is this really necessary? Can I just make decisions as their child or spouse? And I wish the answer were yes, but the reality is no. Hospitals and banks need legal authority. Just being someone's child doesn't give you the right to act on their behalf. HIPAA laws, financial privacy rules, and liability issues prevent institutions from taking your word for it. You need the paperwork or you need a court order. And yes, I know that sounds bureaucratic and cold, but the system exists to protect people from being exploited. Unfortunately, it also slows down people with good intentions who are trying to help. That's why I always say plan early if you can. But if you didn't, if your parent didn't, we still have options. Let's talk about what you can do right now if you're in the middle of this crisis. First, find out whether your parent truly lacks capacity. Talk to the doctor, ask questions, say, "Do you believe my mom is able to understand legal documents?" Because here's something most people don't know. Even with a dementia diagnosis, even after a stroke, a person may still have legal capacity. It's not black and white, it's a spectrum. And if there's any chance your parent can sign a power of attorney safely, legally, and with understanding, we act immediately. Second, gather their records that you'll need. ID, a list of assets, contact info for family members, and any old estate planning paperwork, even if it's outdated. Third, talk to a lawyer, not just any lawyer, someone who understands probate and conservatorship law. You need clear guidance and speed. Fourth, document everything, keep a journal, make notes, save hospital records. It may be helpful if there's conflict or if another relative objects to the conservatorship. And lastly, breathe. I know this is overwhelming. You're scared, frustrated, grieving, and probably exhausted, but you're also incredibly strong. You're doing what needs to be done, even if it wasn't the plan. Let me tell you one more story. It's a man named Darren called me. His father had collapsed suddenly. No POA, no will, no trust. He was in a medically induced coma, and the doctors needed consent to proceed with a critical treatment. Darren had siblings, one of whom disagreed. The hospital wouldn't accept anyone's direction without legal documents. The situation was deteriorating fast. We filed an emergency petition that same day, got a court date the next morning, and by noon, Darren had temporary authority to make that call. It saved his father's life. This is why the law exists, not to slow us down, but to create a path when the road disappears. So if you're facing this moment, if your parent is hospitalized and can't speak or act for themselves and no one has power of attorney, here's what you can do. First, assess their capacity. If there's any chance they can still sign, act fast. If not, request a capacity declaration from their doctor. Prepare to file for conservatorships of the person, the estate, or both. Seek legal help. Don't do this alone. And remember, you are doing the right thing. One more thing before we close. If this episode found you in a moment of fear, I want to remind you of this. It's not your fault. You didn't fail your parent. This is hard because it's supposed to be hard, because love and legal authority are not the same thing. But today, you can do something. You can protect them. You can protect their home, their health, their dignity. You can take the next right step. Thank you for joining me today on Gavels Down, Voices Up. If this episode helped you, please share it. You never know who's pacing a hallway with no answers right now. And if you need guidance, visit thelawyerking.com. My team and I are here to help you one step at a time. I'm Rachel King, reminding you legal clarity is love in action, and your voice deserves to be heard.
That wraps up another episode of Gavels Down, Voices Up. If you found value in our discussion today, please subscribe, leave a review, and share with someone who needs these insights. Your engagement helps us grow and impact more lives. I'm Rachel King, thanking you for listening and reminding you to speak up, because every voice deserves to be heard.